It appears we are here. Hello, everybody, whomever is here today. My name is Keith Cooper. I am the Vice Chair of the Beverly Hills Bar Association Entertainment Law Section, and today's panel is going to be Welcome to AI and the Guilds. What is next? As a preliminary note, I am struggling with English today. I'm going to mention that we are now, the Entertainment Law Section is now sponsored by Lawyers Mutual Insurance Company. And a couple of things about that is for 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. This is something that they are experts at. Their experience also are complemented by the fact that they are directed by a group of dedicated lawyers. They do offer special rates and competitive premiums for a wide range of insurance practice, wide range of practice areas, including entertainment law, and you can see more at lawyersmutual.com. And now I'm going to introduce our speakers today. It is my pleasure to introduce Jonathan Handel. He practices transactional entertainment and technology law at Feig Finkel in Los Angeles. He also practices independently and works as a freelance journalist and media commentator. He has extensive experience representing clients across the entertainment and tech industries. He is the author of several acclaimed books on entertainment, labor relations, and industry dynamics. He's a former professor and research fellow and has been widely recognized for his expertise, commentary, and contributions to both legal and media discourse. Also is David Schraga. Now, before I get into his background, I will mention David is also the secretary of the Entertainment Law Section. He's also a mediator specializing in entertainment media and intellectual property. He has 20 years of legal experience in Los Angeles. His background actually includes working as both an entertainment and IP litigator. He's the former founder of KSW LLP and a senior in-house executive at Miramax, NBC Universal Pictures. He is also a Yale and USC graduate. He went to USC. I still don't hold it against him. He's still a good guy nevertheless. He brings deep expertise I'm a Bruin. Okay, what can I say? He brings deep expertise across film and television industry. He's negotiated deals with celebrities, rights holders, producers, financiers, distributors, and major streaming platforms. So with that, David, Jonathan, take it away.
Thank you. And thank you, everybody, for being here. My university affiliations weren't mentioned, but I'll simply say that I don't hold it against David that he went to Yale. In fact, he's done very well for himself as a Yalie.
We can only guess. We can only guess what your alma mater is. So.
We can only guess. We can only guess. I had the opportunity to go back there and talk about the entertainment industry and entertainment law to the students, and I'll just put in a plug to all of you who reach a certain point in your careers that it's very rewarding to go back to whatever your alma mater is. Absolutely. And speak to the students about the industry. This is an industry that is very dynamic and changes very quickly, as we saw this morning. David, I think maybe it would make sense for me to start with a few remarks on the Netflix Warner deal from the likely perspective of the guilds. And I'll be clear, I don't speak for any of the guilds, even though I was previously at one point on the legal staff at the Writers Guild, and more recently for a couple of years was outside special counsel to SAG-AFTRA. But
yeah, certainly it's been a big day in the industry, and I just also want to say thank you to Keith and for the Beverly Hills Bar for the introduction and the opportunity to participate today, and for our supporters at Lawyers Mutual. Also have some fantastic folks over there we work with. I want to say to you also, Jonathan, it's a pleasure to be on this panel with you today and having this conversation. Coming from the studio perspective and having worked in-house for many years, a tremendous aspect of what we do in order to be effective in our deal making and to get these productions off the ground is working with labor lawyers that we have internally. But there's also some really fantastic folks that we work with in private practice, and you are one of them. Obviously, your reputation is stellar. I'm sure many of us have seen you on TV many times as a commentator in this community, and you're a real subject matter expert when it comes to this. So I'm happy to have this conversation with you today. And as you mentioned, today has been a big day in the news with the Netflix Warner Brothers deal being announced. The broad strokes being that Netflix is going to acquire the Warner Brothers and HBO studios, as well as the HBO Max platform for, I think, $83 billion, I think was the number. And maybe you can talk to us today about what the guilds are going to think of that, since we are here today to speak about guilds.
Absolutely. The DGA has already said what it publicly in a variety, or I believe Deadline reporting, actually. Pardon me if I got that wrong. But what I didn't get wrong is what they said, which is that this deal, quote, raises significant concerns for the DGA. The reason that the DGA is concerned, and then I expect that the Writers Guild and SAG-AFTRA will be concerned, is multifold. One is that a reduction in the number of buyers in the community, in the industry, reduces the opportunities for talent and reduces the leverage of talent, of labor, and of labor as such. It's going to be very interesting to see how this plays out in the upcoming negotiations. The upcoming negotiations will extend, as we'll talk about in a moment, from early spring through the end of June. The deal, on the other hand, if it passes regulatory scrutiny in the US and the EU, and I expect some stormy waters, frankly, the deal is expected to take 12 to 18 months to close. So there's a slight difference in the timeframes there, but not such a great difference when you consider that the deals that are being talked about are most likely 3-year deals. Although some folks have raised a question as to whether perhaps the studios might seek a 5-year deal in this instance. If so, that would be very, in these negotiations, I should say, that would be very unexpected and unusual. But the reduction in number of buyers, the reduction in leverage, and the bulking up of what is already the largest scripted television channel in the world and scripted television operation in this business. And I say scripted because the largest streaming operation is actually not Netflix, it's YouTube. But of course, most YouTube content is not scripted. Those factors are key to understanding why labor would not be comfortable with continued growth and of Netflix non-organic growth acquisition, and also the fact that Netflix is a very pro-streaming, not so very interested in theatrical company, whereas Warner Brothers, of course, is both a streaming operation, yes, and a television operation, yes. And not talking about I'm talking about television production. The cable television networks are not part of this deal, and the deal, if it goes through, would be would not include the spun off cable networks, or to be spun off. But of course, the other thing that Warner Brothers is a movie studio, a theatrical movie studio, and Netflix, even unlike some of the other streamers, which have been more accommodating to theatrical release, Netflix has been very, pro-streaming. Now, they've said that they're going to continue to release theatrically through the Warner Brothers operation label, whatever it becomes if the deal goes through. But I expect that the guilds will have concerns along those lines as well.
I mean, I think you've hit it on the head there in terms of what the issues are. Whenever we speak with our friends in the talent representation community in particular, they're always very concerned about the trend towards consolidation and vertical integration between the studio and the platform businesses. And
Right.
when you get into these competitive bidding situations and things like that, when there are fewer doors to knock on and there are fewer bidders, the value proposition gets tighter for them on the talent and the author and creator side as well. I think you've also hit on an interesting aspect of just the creative conversation that's going on, particularly when you talk about the DGA, and really theatrical filmmaking is really the heart and soul of what so many of the DGA members are committed to and believe in. And I think that there has been some interesting reporting in the trades already about sort of some of the commentary from Netflix, kind of cutting in both ways about, their commitment to continuing versus, how much they really see the theater going experience as being part of what the future is going to be. So I think it's going to be very interesting to see where the rubber hits the road on this.
Look, it's a hard conversation. I had a conversation probably about close to 15 years ago with John Fithian, who at the time was the head of what was called NATO, the National Association of Theater Owners, now Cinema United. I refer to it as the NATO without tanks. And I said to John, how many screens, I know how many screens there are in the US and how many are there in China and how many are there worldwide, cinema screens. And he said, probably 125, 150,000. And I pulled my cell phone out of my pocket and said nothing except, and how many screens of any sort are there worldwide? And he gave me a very, sort of nasty look and said, look, the theatrical experience will never be replicated by anything else. And maybe so, but the fact of the matter is that, especially younger generations, people are willing to watch all sorts of content on cell phones, on laptops, on PCs, on TV screens that increasingly are 85 inches, and even on projection screens that are larger and that are cheaper than they ever were before. Theatrical killed the live stage star. I mean, live stage was once a thriving business around the country. Now it's a thriving business in New York and London's West End and in touring companies. Everything else is supported by, largely by philanthropy and grants. So,
Yeah, I mean, this is
what
a
is the
conversation.
future of theatrical, right?
Yeah, this is a conversation that's been going on, right? This is a trend. This is a post-COVID trend that the theaters have been dealing with. Having worked at Universal Pictures myself, there's some phenomenal people over there who are so dedicated to this experience as well and provide an incredible platform for directors and artists. And it's gonna be an interesting conversation to see develop and to see what the strategy for the business really looks like. So maybe we should just jump into where we are with today's topic, which is to talk about the upcoming guild negotiations. Here we are. It's the end of 2025. The last deals were closed where we ran through 2023, I should say. So we've got the next round of negotiations coming up. And maybe before we get into sort of the prescriptive quality of this program today to talk about what's next with AI and the guilds, maybe we should set the stage a little bit for what was agreed to last time, provide our audience with some context about what the key aspects were of the deals that were negotiated from 2020 to 2023 time period.
Sure. And actually, I realize there's a question and an answer that we didn't address, which is questions and answers. If we have time at the end of the presentation, we will take Q&A through the Q&A box that's on the mostly bottom of your screen in Zoom. If you have a burning question that you want to ask during the presentation, you can ask it at any time, and we may or may not get to it until later in the presentation.
Yeah, we'll keep an eye on it.
But we will keep an eye on that, and an eagle eye, more than likely. So 2023 started in 2022, if I remember correctly. In any case, the DGA went first, as they usually do, and their contract, like the others, didn't expire until the middle of 23, but they like to do deals substantially in advance, and or liked to. We'll get to that in a minute, but the Writers Guild went second, as is typical with them. Their contract expires slightly earlier than the others, May 1st rather than June 30th. They negotiated and then struck. SAG-AFTRA then negotiated and struck, as we know. What were the issues? Minimums were, as always, a key issue, but particularly given the inflation that surrounded COVID. Pension and health, which we refer to typically as P&H. Some folks like to say PH and W, with W being pension, health, and welfare. SAG-AFTRA, for example, got an increase in the earnings caps that relate to the pension plan. So only the way the pension and health plans work, and this is important to understand, is that the companies make a contribution that is a percentage of the compensation that the actor, writer, or director is receiving. That percentage rate varies slightly among guilds and very slightly among contracts within the guild, but right now it's about 21% for each of them, give or take, in most cases. And the thing is, though, with the unions, particularly with SAG-AFTRA, there's a cap on how much of your earnings the companies make a contribution on. So in the case of SAG-AFTRA, that cap was relatively low and hadn't been increased in over 40 years. That results in less money paid out by the studios to the pension and health plans, or to the pension plan in particular here at SAG in this instance. But it also results in less money being received by the pension and health plans if there's a cap. And they cap got SAG-AFTRA got an increase in the cap, which was very much needed for the solvency and for the health, I should say, actually, of the pension plan. Residuals, streaming, especially, was a big issue. Many of you know that I've done a chart of the residual system. Residuals depend largely on what medium something is made for and what medium it's now being released in, and so that suggested a grid. I've done a color-coded chart that you can see a bit of at jhandle.com/residuals. But the one cell of that chart has come to be the cell that means the most, and that's the cell where high budget content is made for streaming and plays on the streaming platform that it was released on, either domestically or foreign or both. The DGA got improvements in the streaming residuals formula, and notably the Writers Guild got further improvements in that formula, and SAG-AFTRA got further improvements still. After negotiations were over, so a number of months later, the DGA got the benefit of what the other two unions, the increases that the other two unions had gained. But
Sort of a catch up, yeah.
They caught up. They were given the benefit of those contractual provisions. That's right. But this was an unusual circumstance because usually we see what's referred to as pattern bargaining, where the pattern set by the union that goes first, by the DGA in that instance, is the pattern that's accepted by the other two unions. Here it was almost more like stair-step bargaining, where each of the other two unions built on the preceding one or two unions. We'll come back to that in a minute, very notably. Writers' rooms, various guaranteed employment issues for writers were significant last round. I don't think that we're going to see much change, maybe a tweak or two around the margins, but I don't think we're going to see much change in when it comes to writers' rooms in this round. And of course, as people know, AI issues were huge. There were a multiplicity of issues related to generative AI, replacing a director with an AI bot, was something of an issue. More so was, could generative AI replace screenwriters with AI written scripts? Could generative AI either do digital replicas of existing performers or create completely synthetic performers? And what is the fate of the business going to be? The fate of the acting profession, the writing profession in particular, going to be? Those issues were very, very hotly debated, obviously generated the most headlines. It's much more, headline worthy to debate whether the profession is going to exist at all than to debate whether the increase in minimums, which is always a key issue, is going to be 2.5% or 3%. Those issues feel more wonky than the AI issues do.
Well, it's interesting, because I think baked into all of what you've just described, and thank you for that, is the negotiations are really a reflection of the evolution of the business itself in many ways, right? I mean, I think, when it comes to like the PH&W we were talking about, for folks who aren't doing these deals every day, I mean, this is 21% that the studios pay to the talent on top of the fees. So if you're paying somebody $300,000 to write a script, there's another 21.5% on top of that that's being paid by the studio into the fund. And obviously the costs of insurance and healthcare are going up in our economy these days. This is sort of a uniquely American issue because of the fact that we have private insurance, whereas many of the countries other countries that have guilds don't even have this type of consideration because of the presence of socialized government-sponsored healthcare as well. And then when you talk about the writers' rooms, again, from the studio perspective, this is the change in the business where we're seeing a movement away from these, 22 episode broadcast shows to streaming shows where you get maybe 8 to 10 episodes. And it's really fundamentally shifted the economics of this programming and what writers were being hired to do and how they were able to survive and make their livings. On the residuals front, I think a lot of us probably heard in the news about Suits, and this is a show that sort of had a resurgence on Netflix and it was tremendously popular. And some of the talent were coming out and saying, well, we're not seeing it in our paychecks, right? So I think there's been a big push to have the agreements reflect and catch up to the reality of how the business is working. And now AI, I think, is filtering into that in all the ways that you just described as well. So Before we get into sort of talking more specifically about the AI issues and where we're heading into 2026, maybe you could sort of talk a little bit more about the structural considerations of how this negotiation is going to go. I know that you have your ear to the ground and lots of folks that you talk to in the industry and some interesting perspectives on how these negotiations might go as we move into this next season.
Yeah, the key thing, one of the key things here is in that regard, is if you put your ear not to the ground but to the window and listen, what you will what you'll hear other than traffic and perhaps a few birds chirping is crickets. You will not hear the DGA negotiating right now.
Hmm.
You will not hear them pre-negotiating. You will not see any announcements that we'll have a DGA deal by the end of December, as we often do. And that's because, and this has not been previously reported, the DGA is not going first this time. The DGA, although they ultimately got what the other two unions got in streaming residuals, felt, I'm always a little cautious when I ascribe to other union, to a union what their feelings are. But I'll say from the standpoint of an observer, it seems clear that the DGA was not happy that, having been told in the room, this is all we can give you on streaming residuals, and this is an improvement. They did get significant improvements, and this is all there is. To then discover that the unions that went later, the unions that are more boisterous, that are a little less restrained in their approach to negotiating style, and in fact, in this last round, were significantly less restrained. They struck. The DGA has struck once in its 90-year history, and that was for 15 minutes or 5 minutes, some people say, plus another 3 hours on the other coast because of the time difference. I mean, literally. The DGA, I think, was miffed and was not happy to see that, having been told this is all we can give, that somehow there was more to give. And so they're not going first this time. They're going last. The Writers Guild is still going up against their May 1st expiration deadline. And so that means that SAG-AFTRA is most likely to go first. The likely order here is SAG-AFTRA probably starting in mid-February, negotiating for 30 days or so. The Writers Guild starting in mid-April, negotiating for, again, roughly 30 days. There'll probably be a week or so break between the end of the SAG negotiations and the beginning of the Writers Guild negotiations. And then the DGA probably mid or late May, in advance of the June 30th deadline. They do not, and what I'm hearing certainly is they do not want to be in this position again that they were in last time, where they, in effect, had to go back to the studios after those strikes were settled and say, we want what you gave them. Now, the studios that they were talking to, the AMPTP, the Alliance of Motion Picture and Television Producers, which is actually an alliance of studios and streamers, not really of producers per se, that is the organization that jointly negotiates on behalf of the studios. And it's composed of a president and various staff members, but small number of people, and the labor VPs from the 8 negotiating companies. There are 8 companies, the 5 traditional studios. We still have 5 right now, and Apple, Amazon, and Netflix. That makes 8. Everyone else, whether you're as big as a Lionsgate or whether you're, a dentist in Chicago who's making a movie, because you have a ranch outside of Peoria that you can film on and friends who are actors. For everyone else, if you're making a movie that's under union agreement, it's take it or leave it. So it's 8 companies. They operate by consent on a consensus model, very important. So if 6 companies in the AMPTP are willing to take a particular position, they're willing to agree to a particular guild proposal, or they have a particular proposal they want to make on, foreign streaming, let's say, or whatever. That's not enough. It's got to, all 8 of them have to be on board before they'll agree to something. That makes negotiation difficult. But interestingly, the president, who is the chief negotiator for the Studio Alliance, has changed. It's no longer Carol Lombardini. She spent a number of decades at the AMPTP.
Widely respected.
With, I'm sorry?
Widely respected for many years.
Widely respected. Spent many years as the number 2 and was promoted, was the number 1, widely respected. The new leader, Greg Hessinger, is a name that some people on this, and a person that some people on this call know well, and that other people will not recognize. But what's interesting about Greg, among other things, he's also respected on both sides of the aisle, as it were. Greg, for a number of years, was the national executive director of AFTRA. And for about 6 or 7 months before a political reversal, was the national executive director of SAG. This obviously before SAG and AFTRA merged, formed SAG-AFTRA. So he should have some, particular insights we're hoping it will ease the conversation even further with SAG-AFTRA, because he's been there and made some of the same arguments and discussions. And the consensus structure of the AMPTP interacts with the fact that now we have a wide diversity of companies that have to come to a consensus before a deal point is agreed to. So at one point it was, 6 traditional studios. Now it's 5 studios, some of which have streaming businesses, others of which don't, some of which are in play, others of which aren't, one of which was just acquired, Paramount. You go on and on. You go down the list, and each of these companies is almost its own animal, and yet somehow they have to come to a consensus.
Well, yeah, sort of coming from my background now as a mediator and a negotiator, where you're working with, diverse parties and you're trying to align their interests to get them to agree. These are critical issues. I think there's an opportunity here to be optimistic. It sounds like, one of the most important things when you're dealing with diverse parties is for them to be able to relate to each other, right? And having been in each other's shoes, and it sounds like Greg Hessinger is somebody who is going to have a perspective, obviously, on what's going on in the other room that hopefully can be very helpful to building rapport and trust and having these types of conversations. But I think you're again touching on an industry-wide issue here, which is that when you have the AMPTP now composed of companies that have some very different business models in some senses, obviously this came up in the last negotiations when talking about the streaming residuals. A lot easier for the studios, or the traditional studios, distributors, I should say, to not worry as much about that when Netflix and the streaming platforms are the ones who are going to be paying them. But ultimately, they did get it hashed out, and it's a great piece of news that you've shared with us today in terms of how we think these negotiations are going to go. Again, from a negotiation perspective, when you have these timing issues to coordinate, it makes things much more complex. So. That's great. That's a great piece of information. Thank you for that. So maybe we should sort of jump into where we are with 2026. I know there's maybe a few big picture non-AI issues just to keep in mind, and then we can maybe turn the thrust of our attention to where we are with AI. I mean, I know we're always talking about minimums and the pension and health plans and residuals, but I think certainly what sounds like the pension and health issue is going to be a big one coming up, and I think they probably dovetail with the AI issues as well in terms of some creative solution making.
Well, it's all of these issues. I mean, I want to start with minimums. Minimums is the least sexy issue, but it's 25. It can be 25% or more, according to some sources, even 75%. But I got pushback from other sources on that, so I'll have to leave it at big and bulky and under, and undersexed, as it were, as far as headlines go. The issue with minimums is this. Historically, the guilds get about a point or so above inflation, and inflation is relatively low right now, which suggests that probably the studios would be looking at most to pay about 3% per year as the increase in minimums. But if you are going out to lunch after this webinar, or if you went to the grocery store earlier in the week and you're eating your brown bag as you watch, that it doesn't feel like inflation is low. It feels, it's just incomprehensible what, it's that much for that. When did that happen? And, we are all still experiencing sticker shock from COVID and post-COVID, and now tariff, supply chain disruptions and commerce disruptions. And now COVID was, 5 years ago. That was before the 2023 negotiations. But those negotiations, although SAG-AFTRA got some increases that were higher than expected, those negotiations did not fully make up for the back-to-back 9 and 8.5% annual inflation rate that we saw during COVID. And so people are still really suffering from that when it comes to housing prices, when and again, actors, for example, I mean, really the whole industry, the largest part of it, obviously Atlanta has become very big, but the largest part of it lives in LA and New York, which are 2 of the 3 most expensive cities in the country. So minimums definitely an issue. There's an interaction with P&H, which is that the P&H contribution, that 21%, for example, the way that gets, if it goes up to 21.5%, let's say, or 22% in the next round, the way that it gets funded is that, let's say the studios and the unions agree to 3, 3, and 3 for each of the 3 years of the agreement for the basic wage increases. And then one of the unions says, we need to increase our P&H funding a bit. Well, they'll divert 0.5% of the increase in one of those years, typically the first or second year, to P&H. And so the actual increase in minimums might be, for one union, might be 333, and for another union might be 2.533. For another, might even be 2.53. And that gets us into the P&H issue. Specifically, as Variety has reported several days ago, earlier this week, I think, the Writers Guild health plan is particularly stressed. The health plan is in poor financial straits, and that there are multiple ways of addressing that. One of them is increasing the contribution to the health plan. Now, you'll remember I said P&H right now is typically at about 21%. Well, P&H are dating, but they're not married, okay? They keep separate bank accounts. P gets money and H gets money. So how much of that 21% goes to pension? How much of that goes to health? Well, it depends on the guild, depends on the union. Different unions have different financial requirements for the pension plan and for the health plan. Different pension plans and different health plans are in different financial circumstances right now. And plus, for that reason, if you asked me that question today, and I looked up the answer, if you had asked me that question 10 years ago, or 5 years ago, or 3 years ago, or 15 years ago, the answer is different every year. The distribution can change even during the space of a 3-year contract, because the overall amount being contributed, stays the same, subject to, permissive diversion of 0.5% or whatever is agreed upon. There are a lot of levers in the health plan to deal with. A lot of them are levers that you're familiar with, even if you're not an actor, writer, or director, but instead get health insurance from your employer or even from a university. What are those levers? First of all, one of them is, what are the benefits? We don't pay for X. We do pay for X. What are the co-pays, co-insurance, and deductible? How much is your deductible? And once you've met your deductible, the plan, will pay for things that we do cover 80%. No, we'll pay 70%. No, we'll pay 75%. $40 a visit to see the doctor. Used to be 25, used to be 15, might be 50 on your plan. Out of network coverage, if you're not with a covered doctor, do we pay it all? Do we pay 60%, 50%, 35%? Do we cover vision? Do we cover dental? But unique to union health plans in an industry where people don't work full time, there is one other lever that is very controversial the adjustment of it is very controversial and yet is very fundamental. And that is qualification levels. So if you work for Google, if you work for, you know, ING Bank, if you work for some insurance company, if you work for whoever you work for, if you
Typical
work
job.
typical job, if you work for a studio as an exec or as a staffer, typically as long as you work 20 hours a week, it's the same as if you work 40 hours a week or 50 hours a week. You're entitled to whatever insurance they offer their employees. That's how that's how qualification works. But how does that work for actors, writers, and directors? Actor, if I work 20 hours a week, I don't have a job. What are you talking about? I'm an actor, or I'm a director, or a writer. There, it's based on total amount of covered income you made in a year or in 4 quarters. Not to get too deep into the weeds, but call it in a year.
Yeah.
If you don't, and the amount differs on different guilds, but if you fall $100 short of the qualifying level, yes, the company made contributions on your behalf. Let's say the qualifying level is 40,000 and you made 39,000 that year. Well, 21% of 39,000 is $7,900 roughly. The companies that you worked for during the year contributed $7,900 to the pension and health plan of your guild because of that work that you did, but you don't get any health insurance at all because you didn't meet the $40,000 qualifying level.
Basically, you've got to earn it out every year in order to maintain your coverage.
It's actually every 4 quarters, and then there's a quarter
Right.
that's blank, and then a very complicated sort of thing. But basically, the easiest way to think of it is, yeah, if you didn't earn that level in the year, then you're not going to get coverage the next year, and you might be entitled to buy COBRA coverage, and you're certainly entitled to go on to the Obamacare, the ACA health exchanges outside of the guild system altogether, but you're not going to get guild health insurance. And that's the way all 3 of the above the line guilds work. And the IATSE it's similar, it's slightly different. So here's the thing: why have a coverage level at all? Why have qualifying level at all? Why don't you set it at $5,000? So if you're acting enough that you earn $5,000 in this business, maybe that's not enough, maybe $10,000, whatever. Someone they've got a connection to the business. Why not set it there? Well, the trouble is, if you set it at that low level, you haven't changed the amount of money flowing into the plan, because no matter what level of income you make in that year, 10,000 or 40, 39,000, whatever, that 21% applies. So the amount of money flowing into the plan doesn't change, but now you have more people eligible. And you say, well, that's great. More people eligible. They get health insurance. Well, health insurance doesn't come from the tooth fairy or by magic. It comes from the money primarily the money that the companies are paying that year. There's also some investment income. So how are we going to accommodate this sudden influx of new people? Well, I guess we have to cut benefits. Wait a minute. I work in this business a lot. He only works $10,000 a year. That's scarcely anything. They're scarcely an actor. In fact, but I, make $100,000 a year in this business, and now you're cutting my benefits again? And you're trying to tell the companies that they got to raise that 21% to 22%. So no, you got to keep that qualification level up. But if you keep it up, you have a lot of union members who are unhappy because they don't qualify. So it's a very, very explosive lever.
It's explosive. It's a thorny issue. I mean, again, I think baked into what you're saying is a lot of things that are going on that in many ways tie back to AI, right? Because what we're talking about is you don't have to go that far, to see that people are having a hard time out there in the creative community, right? I mean, we all hear about the big money people at the top of the heap who have these big deals, but I go to pick up my kid from school, and the other parents are writers who haven't worked for a year. These are really talented folks who have worked on fantastic shows, and they're trying to write spec scripts, and they're struggling to find these new opportunities. So they're not getting paid. Costs are going up. The funds are dealing with this potential insolvency problem if there's not enough money coming in. The amount of production has gone down in the business post-COVID, right? And the strikes
and for actors in particular and crew, the amount of business in LA has gone down even further than the shrinking of the overall pie.
Right. So that's gone down. Now, obviously, there's some new legislation in California with tax credits that's designed
it's having an effect.
Hopefully
It's helping. Yeah.
well, that'll help you, right? And we'll see some good news on that. So, but people are getting pinched who are actually doing the work. The studios themselves feel like they're under pressure, right? I mean, the
Well, they're all
streamers,
getting bought by tech companies.
yeah, the streamers aren't ordering as many shows. They're making more shows themselves. They're acquiring companies like Warner Brothers, right? They're all under profit from Wall Street, under pressure from Wall Street to generate profits. So it feels like the margins are getting tighter. And where's this money going to come from, right? And now we have this conversation about replacing talent with AI. And so you can imagine why it's such an important issue for the actors, maybe more than the directors the last time around, the writers, maybe more than the directors last time around to strike over, because for them, it's a different kind of threat in terms of, replacement of their images and replacement of their written work. So I think it all converges, and now we're talking about these plans. It used to be a thing where you get your SAG card and then you can get benefits, but somebody's got to pay for that, is what you're saying. And these plans are getting more expensive, and the money's going to come from somewhere, right? And these are existential issues for the guilds and for their membership that I think have to be addressed. And these are complex, and it comes back to from the mediator's perspective, where we need to talk about a way to make the pie bigger for everyone so that we can solve these problems collaboratively. This is something Ken Zifrin talked about it recently when he spoke to the Beverly Hills Bar about this issue. And look, there's a fundamental interdependence between the studios, the AMPTP, the streamers, the guilds, the talent, relying on each other, right? So there has to be a collaborative, solution-making approach to this, I think, in order to work through these things.
There does, but getting people to pay more for entertainment product and more people to watch professional entertainment product rather than, kitty cats on parade is, I mean, the era where the only way to watch a movie was to pay what in today's dollars is $20, $25 for a ticket. That era disappeared with rental VHS, with purchased DVDs, with purchased Blu-ray, and now with streaming, where that a little less than that $20, $19 gets you the entire Netflix catalog for a month.
Yeah.
There's no going back to an era that this industry, through scarcity enforced by technological limitations and copyright restrictions, created business models that were very, very lucrative and for a wide range of people. And we're not going back to that era. I do want to say, since you mentioned the S word, I don't think we're going to see a strike this by anybody this negotiating round. This is just too. First of all, it's very rare that the guilds would strike 2 cycles in a row. What's typical is 3 to 4 cycles go by, as they did. We had strike in 2007, then 23. That's 4 cycles, whatever it is. We had the last Hollywood strike before that was 1988. There was a commercial strike, SAG commercial strike in 2000, but in terms of Hollywood, it was 20 years, 4, maybe even 5 cycles.
Wow.
There were multiple sequential strikes in the 80s, but that was unusual. I want to mention pension levers briefly, and then another bit of news. Pension levers, how the pension plans are funded through long-term investments as well as the contributions that are made in any given year. And so the health of the stock market, and these are stocks and bonds and alternative investments and so forth, the savvy of the professional investors, all of that make a difference. The levers include things like the pension contribution rate, the caps, the actuarial assumptions you make on what the future is going to look like, and the so-called accrual rate, which is a complicated actuarial variable that basically controls how rich a pension is going to be, how robust a pension is going to be for a given level of income. Pensions are very different, by the way, from IRAs and 401ks. I'll leave it to you to, if you're not familiar with those differences, to Google, because they work in extremely different ways, but ways that are very complex. Now, because of that complexity, it's very hard to merge pension plans. SAG and AFTRA merged, the unions merged in 2012. Their television contracts, which was where they overlapped, merged in 2014. Took 2 years, and the next cycle for their television contract for there to be a merger of the contracts. The health plans of the two unions didn't merge until 2017, a date that I actually first reported as an exclusive in the Hollywood Reporter when I was writing for them. And that was 5 years, 4.5, 5 years after the merger of the unions. But the pension plans, the SAG pension plan and the after retirement plan, have not merged. It began to look like there was going to be no movement towards merger at all. And that is largely because the mathematical, actuarial, statistical, and economic way that the retirement plans, pension plans are structured is so complex that you can't just glom the money together and say, well, this one had twice the money of this one, so this one gets twice the benefits. And it just did not.
It's ERISA issues, right? Really
Well, that's
complex.
not even to get to the legal issues
Yeah.
under ERISA. That's right. But just the mathematical issues of what would it mean to merge, two retirement plans. However, what I can report is a step in this direction. Again, this has not been previously reported. The plans are composed of a pension plan conceptually is composed of two things. It's composed of a big bank account, so to speak, a big brokerage account, really, with lots of investments. And it's composed of a staff that do a lot of things like run computer models, send out checks or electronic payments, govern the thing, do accounting, do HR. Well, why can't you merge those things, those back office functions? Actually, you can. And the trustees of the SAG pension plan and of the AFTRA retirement fund are currently at work towards finding a way to merge the two plans together, even still having to maintain separate brokerage accounts. So it's a very slow process. I mean, it's been 13 years since the unions merged, almost 14 years. But this has not been previously been reported. The trustees are working on merging, and that merger would, of course, would reduce, like any corporate consolidation, is intended to reduce operating costs, and reducing operating costs on a pension plan are certainly a good thing. At least more money for benefits.
Sounds like it'll be helpful.
Right.
Excellent. Well, thank you for that. Another really fantastic tidbit from you here today on that. So maybe, we've got about, I think, 10 minutes or so, 15 minutes or so left, and maybe we could just sort of jump into what we're looking at as we move into the next round with some of these AI issues for the various agreements. I thought maybe we would just jump into the performer agreements.
Sure.
And maybe if it would be helpful, we could talk about what was agreed last time. Maybe I could run through sort of some of the high level points in terms of what was agreed to last time. And I think what's really interesting is to hear your perspective on what's been agreed to since then in terms of some of these other agreements that are out there as predictors for what we may be dealing with.
Right. Before we do that, I wanted to simply say on residuals, I would expect some incremental improvement in streaming residuals, but no huge changes.
Okay.
And there are guild specific issues for each of these guilds. What about stunt performers? What about stunt, et cetera, et cetera. There will be a whole bunch of, issues to be negotiated, especially for SAG-AFTRA. But let's move on to AI.
Sounds good. So last time around, in terms of the performer agreements, what were some of the top level things that were agreed to? The most important thing was that for employment-based digital replicas, if you hire a performer to be in a film or a television series and you're going to create a digital replica of this actor, you are only allowed to do that with clear and conspicuous consent in a written contract. And that had
compensation.
And compensation, exactly right. And the studios really responded to this. The contracts look different as a result of this. There's new practices that are in place. It has to be used in the same production. And if you wanted to use that digital replica in a different production, consent and separate bargaining for separate compensation was required. It couldn't be pre-obtained unless it was part of like a multi-series or multi-film kind of deal. When it came to things that were independently created digital replicas, where you're creating a digital replica that looks like a real performer, but you're not actually imaging them and taking their photo in order to create that, the agreement provided that they had to obtain clear and conspicuous consent, again, in a signed writing prior to the exploitation, with a reasonably specific description of what you intended it, how you intended to use that independently created replica. When it came to digital alterations of those replicas and of images of performers, once again, clear and conspicuous consent was required, along with reasonable specificity of what you're going to do. There were some important exceptions that were sort of a continuation of how the business was already working. If you're going to use it for dubbing purposes or to do, visual face alterations, mouth alterations for things like that, alterations in post, a continuation of currently existing technologies. That's not what we're really talking about. Then we get into this really interesting area of synthetic performers. We've heard a lot about this recently in the news with like the Tilly Norwood type performer that's been announced. It kind of breaks into two different distinctions. One, if it's based on someone real, again, you have to get their consent and bargain if you want to create something that looks like Tom Cruise, let's say, is the most extreme example. When it came to synthetic performers based on someone who's not real, it was kind of kicked down the road a little bit, the issue of how are we going to deal with this? And what was agreed to was a producer had to give SAG-AFTRA notice and an opportunity to bargain in good faith about using that performer in place of a real person in a human role. The big loophole is it doesn't apply to non-human roles, right? Aliens, robots, things like that. But there's some overlap, right? Because oftentimes humans are being used in those roles. There's motion capture, so there's some gray areas there. But that's sort of where things were left. And we do see this sort of coming into the conversation now about these synthetic performers. And so maybe, Jonathan, you could speak to us about what's been agreed to since then, because there's been like a verticals agreement, a commercials agreement. I think they may sort of help us read the tea leaves on where this is going, especially when it comes to use of synthetic performers.
Well, that's exactly right. One of the secrets about SAG-AFTRA that's not so secret is that the TV theatrical contract every 3 years is not their only agreement, and we've had a number of other agreements, of which the two that you mentioned provide interesting bits of background. I'll start with the commercials agreement. Synthetic performers cannot be used primarily or materially, to quote the language, for reasons of economy. If there's an actor available, but if they can't find the right look, they can use a synthetic performer, and if they violate this, they have to pay the equivalent of what a human performer would have been paid, both session fees and use fees, residuals, into the P&H fund. Interestingly, since there isn't an actor to pay it to, because by definition there isn't an actor, they violated the provision. So that is a creative area where you say, okay, what are we going to do with this? Well, now why, you might say, oh, so the union got into the P&H. Well, wait a minute. Remember, the companies make contributions to the P&H fund, the 21% that I was talking about. So by having the companies pay this penalty, but they don't pay it to the union, so the union gets fat and happy, and the companies say, we don't want to make the union fat and happy. It goes in the P&H fund, which then reduces pressure on the companies the next round to increase contributions, increase that 21% to 22% or whatever it might be. So it's a very creative solution. The money goes to a place where both labor and management get benefit. And by the way, these funds are governed 50-50 by boards of trustees that are 50-50 labor and management.
But I mean, this all ties back to what you've been talking about for us during this entire seminar, which is that there's so much pressure on these funds because of the reduction in production and the
increase in health costs and the
increase in
stock
costs and
market
things like
up and
that.
down and
And
all
so
that. Yeah.
now we have this convergence because now we have this concern about, well, you're effectively using synthetic performers instead of hiring real people. It's not a perfect solution, right? Because in theory, the unions still want a real person to be hired, right? But I mean, they're sort of trying to thread the needle here. And the solution is at least we can take that money and put it into the fund that's going to support solvency and providing health and welfare to these actual real people who aren't given the opportunity to do the work and pay into themselves. Not a perfect solution, but a creative one, I think, that that sort of balances those tensions.
That's right. Now, what was also, and there's some other, if they're using it not just to save money and so on and so forth, we don't want to get lost in the weeds. But training data was the other interesting thing that was kicked down that can was kicked down the road before. But here, the results and proceeds of covered services cannot be used to train generative AI systems without union consent. So that is the beginning of the union saying you can't use covered work for as training data. Now, what about in an area of scripted production, verticals? The verticals agreement, these are micro dramas that play vertically on your cell phone, and that are 2-3 minutes each, and have become a huge business in China and becoming a big business here. The verticals agreement is interesting because it's a promulgated agreement. In other words, it's an agreement that SAG-AFTRA drafted itself and didn't negotiate with any studio or company or producer. So it shows us what the union wants and what the union thinks it can get that the union feels is still reasonable, but without the constraint of you got to persuade the other side or a consensus of the other side to agree to. As far as synthetic performers go, producer can't use a fully synthetic performer in place of a performer who would have been engaged in a human role without first bargaining and getting the consent of the union. So it's just absolutely prohibited. The union will presumably want payment probably somewhat along the lines of what we saw in the commercials agreement. Digital replicas, all copies of digital replicas have to be deleted within 90 days of the final edit. And they have to take commercially reasonable steps to ensure the data security of any digital replica. And in training data, no content, audio or video, can be used for machine learning, including model creation, period, full stop, end of story.
So here's where we're seeing an evolution of the guild's position from, well, we have to have a good faith conversation about it, to you can't do it without our consent when it comes to using these synthetic performers. And obviously this is an issue that's going to run through the other agreements as well, because there's a creative issue here. I mean, we've all seen Guillermo del Toro accepting awards, for the latest Frankenstein film and talking about how he feels about not wanting to use AI. And I think a lot of these things with directors and things that get worked out at the relationship level, right? But I think as a fundamental matter, this is writers, do actors want to even be in these performances and in these projects if other synthetic actors are going to be used, right? There's a lot of pushback on this Tilly Norwood story, obviously from a lot of performers. So I think that's a really interesting evolution that we've seen in their position. I think that the training data issue is one that is fantastically interesting as well. That's going to weave through each of these negotiations very clearly. I mean, we see all these suits going on right now about training data.
Let me mention something particularly interesting about training data and the Writers Guild. The other two unions, the directors and the actors, if film footage, TV footage, whatever, is reused, they get a residual. With the writers, if film footage that they wrote gets reused, they get a residual. But there's a different kind of residual that's not called a residual that the writers also get, because the writers actually oversee two kinds of things that can get reused, not just the ultimate footage, but the writers also contributed to something that we call a screenplay or a teleplay that the footage was then based on. What if a screenplay gets reused to make a stage play or to make a remake or to make a sequel? Well, in many circumstances, or what if a television series is a spin-off series, the same kind of situation. In many circumstances, writers are entitled to what's called separated rights. It's a completely different title. It's not called residuals. It's called separated rights. But it gives them certain controls over those reuses at all, and gives them certain compensation and bargaining rights. And there are ways of defeating certain of those rights by paying them enough up front. It's very complicated. But the point is that writers already have precedent for saying, when we make stuff that gets reused, it doesn't have to be the final footage that gets reused. We still, under some circumstances, get compensation. Well, guess what? If the final footage, or if a screenplay gets reused as training data, you're reusing the screenplay. We already have separated rights. If you reuse the screenplay to make a stage play, You don't get to do that. I get to do that for the first 3 years and blah, blah, blah. And there's a back and forth and reversions and all sorts of things. But I get money for it. So if you're going to use me for training data, maybe I have the right, maybe I want the right to prohibit that altogether. And if not prohibited, maybe I say, fine, you're reusing the screenplay, even a screenplay perhaps that you never produced, but that you bought. I want to get paid for that. So
Well, and I guess
it's an issue that casts a shadow on all three negotiations, but the shadow has different and very complex shapes that differ among actors, writers, and directors.
yeah, I mean, what I hear you saying is from a guild perspective, there's already a conceptual framework that's in place, built into these agreements that provides for compensation for reuse of the actual film footage itself or the underlying creative material that's the seed and the basis for a derivative production like a remake, a sequel, a spin-off or something like that based on a film or a TV series. I mean, I think that it's a really interesting concept and the real challenge I think for the guilds is going to be, the flip side of that is that these generative AI large language or large learning models, they ingest a tremendous amount of material, right, in order to create these tools that we use to generate new screenplays or new backgrounds or new audiovisual content. But it doesn't necessarily look anything like, or a whole lot
But it
like
doesn't have to.
the same way.
If you think that's an argument, it doesn't look like my script, then don't ingest my script. Fine. You say you want to ingest my script? Well, then pay me.
Yeah,
You
well,
want to
that's the
ingest my
question.
footage? Then pay me. Don't tell me that just because you ingested a million other people's that I don't get anything. Now,
Right.
yeah, I don't get the level that I would get if it was just based on me and it looked like me and it was let alone an infringement type thing. There is another hard part to this though, which is that the background law is unsettled. Right now, third parties are ingesting pre-existing material and not paying anyone for it. They're not paying the studio and they're not paying the creatives. The courts have not yet decided, nor has Congress decided, and it'll take several years for anyone to decide definitively whether that is fair use and can continue to be done without paying anybody, or whether it's not fair use, in which case, if the studios have to get paid by a third party, then the studios should pay the creatives as well. It's going to be the union position. But it's been hard for the union to say to the studios, you got to pay us, but some willy-nilly infringer type, bad thievy guy, in our point of view, doesn't have to pay you because the courts say he or she doesn't have to pay.
Yeah,
That's a hard argument to make.
there's a lot of layers here. Yeah, for sure. The real
Right.
question is what is the appropriate compensation model for something like this when we're
Well,
talking about this type
right.
of new technology and how it's going to be implemented? And then, of course, another interesting layer is, we're talking about the guilds potentially taking the position that you can't use these types of tools within productions, and you can't ingest material in order to
Well,
create
again,
performance
it's
without paying
consent.
us. So there's a lot of these tensions back and forth.
Right. It's consent, compensation, and the background question of will there be compensation and consent rights at all?
Right, absolutely. Well, look, I mean, I think we have come to the end of our hour here, so I think we need
Yeah.
to wrap it up. But I think we really have hit on what the key issues are going to be as we move into this, right? I mean, synthetic performers, training, use of these underlying materials. How do we deal with the costs of these funds increasing? Um, and also the new technologies that we're seeing and the new formats within the verticals and things like that too. So um, I don't see any questions in the Q&A, so I think we probably can wrap it up at this point. And I just want to say again, thank you so much for your perspective on this material, for your investigative services and breaking a few stories for us here today in terms of what we can expect. I think we'll probably see some of this reflected in the trades pretty soon. And thanks again to the Beverly Hills Bar, to Lawyers Mutual for supporting us, and to all of our audience for participating. Anything else I forgot, Jonathan? You want to add a closing remark?
Of course I do. I want to thank you for being a
You
wonderful
bet.
co-panelist and for being here. You kept us on the straight and narrow, and perhaps after SAG does their deal, SAG-AFTRA, we'll be back.
Yeah, well, I think that, talking about hopefully there won't be any strikes is a very optimistic place to leave this. Again, as a mediator, my perspective is always going to be there's a collaborative way to address these things. It's great to know that the top level folks can get into the room and talk to each other and work things out if that's what's necessary. And hopefully, like I said, there's a way to make the pie larger, right? So that we can have a win-win resolution of these issues for everyone in an industry that means so much to this town and to the world community, and really affects people's lives on a day-to-day basis here. So thanks again for all the work you do as well.
Thank you. Thank you, everybody.
Thank you, everyone.